Anna, don't we have Airbnb first?
We do. I'm trying to turn their video on. I've just turned it off.
I just saw Mr. Heitman pop up, who is
right.
Second case.
Right. I just turned his video off. All right. Judge Katsas, would you like me to open court?
Please do.
Thank you. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-7168, Gregory Selden, Appellant versus Airbnb, Inc. Mr. Emejuru for the appellant, Mr. Morota for the appellee.
Mr. Emejuru, good morning. Whenever you're ready.
Good morning, Judge. Good morning. My name is Ike Emejuru. I'm the counsel for Appellant Gregory Selden, and may it please the court. Today, the court is hearing Mr. Selden's appeal based upon his belief that he was not provided reasonable notice of arbitration terms, that his arbitration claims, that his claims brought in the district court are not arbitrable, and that he was not given a fair shot at the arbitration during the arbitration proceedings. First and foremost, Mr. Selden does not believe that he was provided reasonable notice of the terms and conditions provided by Airbnb. As we now know, based upon case law and various circuits, that a consumer must be given, reasonably proven consumer or internet user must be given notice of terms and conditions before they sign up or receive of any services from an online organization or company.
Is your theory that any sign-in wrap, by definition, is insufficient notice?
You know, Judge Katsas, that is not our theory that any sign-in wrap, but we do believe that a sign-in wrap should provide clear, conspicuous notice of terms.
So if it's not the fact that someone had to click on the link, what else could possibly be insufficient with this? You have the 3 sign-up options, and then immediately under it, you have a simple statement: by signing up, I agree to the terms, and there's contrast in the color, and it's simple, and it's right there.
Yes, Judge. So the sign-in procedure that Airbnb put forth has 3 different sign-up buttons. Mind you, let me draw the court's attention that this was 2016, so right now it's slightly more, the consumer has gotten a little more prudent as to what's going on in terms of signing up. But if you take a look at the sign-in procedures, it's a sign up with Facebook, sign up with Google, sign up with email. The sign up with Facebook does not suggest that you're signing up with Airbnb. It's a sign up with Facebook. So sign up wrap that you're looking at before you may confuse or provide a confusing idea to this consumer that you're going to sign up with Facebook rather than signing up with Airbnb. It is one of those advertisements or other types of companies unaffiliated with Airbnb that the courts and Nicosia and the Amazon and Cullinan have discussed as problematic for consumers. So if you also look at the sign-up mechanism or procedure, sign-up mechanism from Airbnb, you look at it's a sign-up with Facebook, but nowhere underneath that sign-up with Facebook are there terms and conditions placed underneath so that the consumer knows that they are signing up with Airbnb. Mr. Selden, in this case, it's undisputed that he signed up with Facebook. Once he signs up with Facebook, it takes him to another page. It takes him through Facebook's mechanism and then back into getting into Airbnb to continue the process of looking for accommodations. I think that in itself is also confusing for a consumer and not necessarily something that is in line with the case law that was.
Mr. Emejuru, what about the Second Circuit's decision in Meyer versus Uber? I mean, the website there seems very, I mean, of course, it's not binding on us, but the website there seems very similar to the website that Airbnb used. And there it was found the Uber website was found to provide reasonable notice. I'm wondering, can you distinguish the Airbnb website from this Uber website?
Yes, Judge Rob, I believe I can. I think that if you take a look at the mechanism, first of all, there's two different sign-up screens for the Uber case. You have a register sign-up and a payment sign-up. So that's two different screens. So the register sign-up in Meyer has the Google or Facebook button at the top, but there's no terms and conditions in that particular registration page. The second payment page has the terms and conditions that has nothing with a Google or nothing with a Facebook page that leads the consumer to believe that, that can distract the consumer, I should say. If you look at the payment button or payment options in the Meyer case, it has the mechanism for the consumer to pay, and at that point in time, the consumer knows, hey, I'm paying for this service, and it's time for me to agree to these terms and conditions, right? But in this particular case, in Airbnb's case, the sign up Facebook, Google, or email are all in one page with the terms and conditions, but the consumer can easily be led away by clicking the button right away with Facebook and then becoming distracted with the Facebook button and the Google button. I think that's
So your theory is that because there are these other platforms, either Facebook or Google, that's distracting from the terms and conditions of Airbnb.
Yes, yes, that's right. I think that is the theory in this particular case. That and also the other distracting terms and conditions that are in red font below the sign up with email button. I think the red font that matches, that doesn't match the other buttons above that are distracting for the consumer.
And in the Meyer case, when you click on Facebook, don't you travel the same route you do in this case? Because on your registration page, you must click either Google or Facebook. And you said you were concerned because if you click on Facebook, then you're sidetracked. Well, that would be the same in Meyer, no?
No, Judge, I don't think so. I'm not sure how the payment processing would work at that point for a consumer if they're rerouted from the Facebook page back to whatever service they're using on Uber. So I'm not sure about those particular facts, but I know that once the consumer in Meyer is on the payment page, they know that they are still working with Uber.
No, I understand what you're saying there, but one of your arguments here was that to get started, you have to click, say, for example, Facebook. Well, that's true in Meyer as well. You have to click on either Google or Facebook. So you're saying that's a distraction. So you don't click on next in Meyer first. You have to click on Google or Facebook, or you do the sign in below. So I'm not sure. I'm trying to understand why that's less confusing in your mind.
Well, I'll also take, Judge Edwards, if you take a look at the nexus between, so if you take a look at the Meyer screen, the register page, there's also nothing on that register page, the registration page or box that has anything to do with the terms and conditions, I believe, until you get to the payment page. So the consumer is being led to Facebook will then go into another orbit, I believe, and not understand whether those terms and conditions apply to Uber as opposed to Facebook.
Okay.
This particular, if the consumer in Airbnb signs up with Facebook or signs up with Google, I think that again, it provides a distraction of different advertisements. Also, the fragmented screen, which Mr. Selden had raised in his brief, is also a distraction as well. You have the or here within the same screen, within the Airbnb sign-up screen. The or is also separating both of the companies. Again, a user, a reasonably prudent internet user may be confused, I think, at that point between where, in fact, or whose terms and conditions are applying in this particular case.
Manager, can I ask you a question about your argument about Title II prohibiting arbitration of these claims? I'm wondering, can you point to any other federal statute that that specifically prohibits arbitration of claims under that statute, or any case interpreting a statute to prohibit arbitration of claims?
Your Honor, so we didn't provide any other statutes that prohibit arbitration, but I think that it's very important that this court look at the language and text of the statute. I know I've emphasized it enough in the brief, but again, this statute in 1964 came out after the arbitration, or FAA was passed. I think looking at the text of the statute saying without regard, which means notwithstanding, it doesn't matter whether someone has gone through any type of administrative process or remedy of law. I think that in itself suggests that that arbitration is inapplicable to this particular statute. I think that federal courts, given case law and cases that we cited, suggest that this particular statute is in the purview of the federal courts and not within arbitration or within an arbitral form.
Yeah, I was unable to locate any analogies, right, where courts have actually read a federal statute to prohibit arbitration. And so I just think there's such a strong presumption in favor of arbitrability. And even, in the Title VII cases, arbitration is permitted under Title VII. So that's why I was just looking, if there were any other examples of statutes.
Judge, sorry, the statute that Title VII does not have the same language as Title II. The statute was written in 1964. I don't think they would have. 1964. I think that the language within Title II pertains exclusive, and the without regard is not contained in subsequent statutes like Title VII. It is within the Age Discrimination Act, exclusively of the federal courts. I don't believe that it's another any other statute except for Title II with that particular type of language.
Anything else, Judge Raff?
Yeah.
Judge Edwards?
No, thank you.
Okay, you're a little bit over time, but we'll give you some rebuttal.
Thank you.
Mr. Murata, good morning.
Morning. Thank you, Judge Katsas, and may it please the court. Sean Murata on behalf of the Appellee Airbnb. There are essentially three questions in this case: contract formation, enforceability of the arbitral agreement, and then vacatur of the arbitral award. But I think, like my friend on the other side, I'll spend most of my time on contract formation this morning. On contract formation, the question is whether a reasonably sophisticated smartphone user would find the terms reasonably conspicuous. And for those following along at home, the key screens are JA201, which is the initial three-box screen, and JA205, which is the second screen that you would see if you clicked sign up with email. Because one of the discussions today has been about that first screen, and as the district court found, that first screen and the first sign up through Facebook is all the court needs to affirm to decide this case. But even if the court had any lingering doubts about that first screen, don't forget that Mr. Selden signed up twice again through the second sign up with email process, in which he would have seen a second screen, which again warned him about what he was about to do by clicking the sign up button. And note that that second screen places the warning about by signing up, I agree to Airbnb's terms of service, above the sign up button, which reduces any concerns about people being distracted or somehow clicking on the button before you've entirely taken in the page. But even with regard to the first sign-up screen, my friend has cited no case where a sign-up with Facebook button, which, as the court noted, is a fairly common feature across apps, which allows people to create their accounts by filling in personal information from other services that they may use, does not provide reasonable notice. In fact, Myers in the payment screen, which is what we replicate at page 28 of the red brief, has the same divided setup. In fact, in that case, you had the registration or the sign up with email equivalent at the top and the buttons for signing up with Google Wallet and PayPal at the bottom, and the warning about by signing up, I agree to following it, and that was found to be sufficient. And there's really four features about Airbnb's sign-up page that make it reasonably conspicuous here. First, the by signing up warning appears roughly in the middle of the page. It's in close proximity to all three boxes. Second, the links appear in a dark red font that contrasts with the white background and contrasts with the black text around it. Mr. Selden argues in his brief that the mix of colors would be confusing. In fact, it's the mix of colors that makes it conspicuous, because a reasonable internet user would understand, oh, if some text is black and some text is red, what makes the red text different is it must be a hyperlink. And third, the text is clearly legible. It's roughly the same size as already an Airbnb member, sign in, which again gives a hint that it's a hyperlink, because if you see a login that's in the red text, you must realize that, oh, the other red text must be hyperlinks as well. And the page is simple and uncluttered. The only elements on the page are the three sign-up buttons, the by signing up I agree warning, and the already an Airbnb member statement. That's all that's on the page. So there's nothing to draw the user away or distract them or to keep him from noticing the terms of service link. And so for all those reasons, it's a reasonably sophisticated internet user, not someone who's dropped it from Mars and has never used a computer before, but someone who uses a smartphone in their everyday life would understand what he was about to do by signing up. And courts have routinely held that this kind of sign-up wrap is enforceable. Judge Rao, you asked if there are statutes that categorically do not allow for arbitrability in the Title II context, or you asked regarding Title II. One example is the Automobile Dealers Fair Day in Court Act, I think it's called. And what that statute simply says, and says quite clearly, is there cannot be pre-arbitration disputes for claims that arise out of this act. So when Congress wants to make something non-arbitrable, it rarely does it because of the strong principle in favor of arbitrability, but it does so. Also, the Federal Arbitration Act itself has exclusions to arbitrability, such as contracts that involve, I think, interstate transportation and commerce. Title II, by contrast, says that there's federal court jurisdiction under it, but that does not displace the arbitral forum. And it says that the remedies in the statute are exclusive, which is fine, because under the arbitration agreement, Mr. Selden could have received every single remedy that's available to him under Title II or any of the other statutes.
Is there any case law that construes it the way you want us to construe it?
Title II, my understanding is there's no Title II specific arbitrability law, I think, because Title II claims themselves are fairly unusual in the federal courts. But of course, Title VII...
This language is not typical. Are there any other statutes with this language that have reached the construction that you want?
I don't know if, with regard to the language...
This is not usual language. And I see how you're trying to parse it, but where is that coming from?
Well, I think it's coming from two places. The first is just the general presumption of arbitrability. Which
okay, forget that. I understand that. But the problem is you have the general presumption of presumption is rebuttable. And so the question is whether this language, which is not typical, it's just not typical language. It says this is the exclusive, suggests this is the exclusive remedy, and you're in court. Are there any other statutes or any case law construing this statute reaching the result that you want? Because it's not self-evident to me. When I first read that, I just didn't remember it. When I first read it, it did not occur to me that the construction you're giving it is the plausible construction.
I think it's the plausible construction, Judge Edwards, for the simple, and let me answer the question first, is I'm not aware necessarily of any case that construes Title II and arbitration, and I'm not necessarily aware of other statutes that use the exact same language, though I'm not going to say they're not out there. But I think... I'm assuming you would have found them if they were there. I assume I would have as well, Judge Edwards. But what I would say is that, the burden falls on Mr. Selden to show that the language admits of the construction that there is... Well, I mean, what I'm suggesting is the language facially admits of the construction that they're propounding. And I'm trying to figure out why we would go in a way that's inconsistent with that language, which suggests that the exclusive remedy is in court. Well, but I would disagree, Judge Edwards, because the language in the statute doesn't say the exclusive remedy is in court. It says federal courts have jurisdiction, and it says that the remedies in this act are the exclusive remedies. But they never marry up the two and say the exclusive remedies are in court. So what that means is that, for instance, you can go to federal court. You don't have to exhaust remedies such as under Title VII when you have to go through the EEOC. And it says that these remedies are the only ones, so you don't supplement them with common law remedies. But the statute never says the exclusive remedies are court remedies. And that's the key part.
Can I press you on that a little bit? Because the statute says, I agree with you on the jurisdictional provision, but then there's a remedies provision. And it says the remedies provided shall be the exclusive means of enforcing. Now, the word remedies is a little bit ambiguous. It could mean form of relief, but it also could mean forum or tribunal, right? We often speak of judicial remedies as opposed to arbitral remedies. And this statute talks about remedies as a means of enforcing, which to me at least somewhat suggests or connotes a forum rather than a type of relief.
I would disagree with that, Judge Katsas, because I think when you speak of the remedies, it's talking about, we're not supplementing with common law remedies, let's say. Instead, what it's saying is that the remedies that are in this act are the only way you are going to enforce the act, not other things that you might draw from the common law. And of course, if there's anything settled in the arbitrable case law, it's that it is perfectly fine to simply swap out a judicial forum from an arbitrable forum, so long as you could get the same substantive relief you could have in court. And I don't understand your forum to be one of the remedies that's afforded under the Act. It might be the place you bring the suit, but it is not one of the remedies that the Act provides. In fact, I'm not aware of jurisdiction being a way that you enforce something. It might be the place you go to enforce something if you're parsing the text, but it's not an actual enforcement of the Act. But even then, you have to consider that, to the extent you may think there may be an ambiguity in the language, all of that has to be read against the general presumption in favor of arbitrability that says that if Congress wants to make something non-arbitrable, it has to be fairly clear in doing so. And so, as I said, in the Automobile Dealer Fair Day in Court Act, it just simply said, these claims may not be arbitrated, at least in a pre-dispute way. The Federal Arbitration Act itself carves out certain things. So, to the extent you think there is some play in the joints in the language, I think the presumption carries us the rest of the way, unless the court has further questions.
Judge Rao?
No.
Judge Edwards?
No, thank you.
Thank you, Mr. Murata. Mr. Amajura, we'll give you a minute.
Thank you, Judge. I just wanted to touch upon a couple of points from my colleague, Mr. Murata. I think, again, I tried to make the distinction to the court of the payments screen versus the sign-up screen, and Uber and Meyer versus Airbnb. But again, let me just touch upon the Title II statute really quickly. I think that the court must take a look at the intent and purpose of the statute. I don't believe, I still rely on Atlanta Motel as our principal case, and I think that the intent and purpose of the statute is within that case. I don't think that Airbnb has even tried to distinguish that case or looked at the purpose and intent within the briefs. But I'll also suggest, Your Honor, that the remedy is the form, and that the federal courts provide promote or advance the intent and purpose of Title II of the statute itself, and that is all that I have for my last minute.
Thank you, Mr. Amajura. The case is submitted.
Thank you, Judge.
Case number 20-1006, National Lifeline Association Petitioner versus Federal Communications Commission and United States of America. Mr. Heitman for the petitioner, Ms. Flood for the respondent.
Good morning, Mr. Heitman. Please proceed.
Good morning, Your Honors, and may it please the Court. I'm John Heitman, appearing today for Appellant National Lifeline Association, or NALA. I'd like to reserve 2 minutes of my time this morning for rebuttal. My focus today will be on the plain language of 3 FCC rules to demonstrate that the order is not in accordance with the FCC's own rules and therefore violates the APA. The Supreme Court's Kaiser decision makes clear that an FCC order that it runs contrary to its own rules is not entitled to any deference. The non-reimbursement order must be vacated because it's not in accordance with the plain text of FCC Rule 54407A, which we call in our briefs a snapshot rule, but today I'll refer to it simply as 407A. The order also cannot be squared with the plain text of Rules 407C2 and 405E3. I'll now walk Your Honors through the plain text of each of these rules so that I can demonstrate that there is only one reasonable construction of these rules, and it is that carriers are entitled to support for Lifeline service provided to subscribers for whom the 15-day non-usage cure period has not ended as of the first day of the month. You can find the text of the relevant version.
Mr. Hudson, if I could, before we get to the merits, could I ask you about your standing in this appeal? Yes. So what exactly is the theory of standing for your organization? Is it based on increased administrative burdens, or is it based on the harms in the Dorwart Declaration?
You know, I would say it is based on both, right? NALA is the industry association that represents a group of providers and carriers in the Lifeline program. And so its members join NALA so that they can join together, and it represents its interests, just like many other industry associations before the agency. And so NALA itself is burdened because NALA now has to shift resources to this appeal. Into this case, as opposed to doing other things that NALA would do for its members. The members who are members of NALA are also burdened because they have a going forward burden of not being able to receive reimbursement for the Lifeline discounts provided to consumers going forward. But more importantly, perhaps, is that
they do get reimbursement if a subscriber actually uses the service during the cure period. They're able to seek an adjustment. So they do get paid. It's just a question of the timing of the payment.
Yes, Your Honor, if the subscriber cures during the cure period. But this is a case about a subscriber who is in the cure period and has not cured. And they have 15 days to cure.
But
so we cannot know. Go ahead.
The declaration focuses on the harm of not being reimbursed for someone who does cure.
Actually, I would have to pull the declaration, Your Honor, but the case, and we have briefed the case, and we have certainly made clear to the court that there are harms going forward in not being reimbursed.
What are those harms specifically, though?
The harm is that the subscriber for whom we provide service to during the cure period, we provide service to. And if we don't get reimbursed, our reimbursement goes from up to $34.25 down to zero by virtue of the FCC's rule. And not only does it go down to zero presently for customers we serve, it goes down to zero for customers we serve in the future. But perhaps more importantly, we have a massive retroactive liability exposure that has happened here because of the FCC's change in its view on the rule when it ruled on the NALA petition back at the end of last year. So under the FCC's change, the FCC, who had been paying reimbursement for subscribers in their cure period, because we have to provide service to them, Your Honor. We have to provide this kind of Lifeline service to them, and the FCC is reimbursing them.
I guess what I'm not seeing in the record, though, is what is the cost of providing a service that is not used? I mean, the FCC at cost is de minimis or non-existent, and I guess I'm not seeing in the record what the cost is to the providers who are providing a service that's not being used.
Yes, Your Honor. First and foremost, this case is about Lifeline, which is a discount program, right? The Lifeline program provides us with a reimbursement for a discount. So we lose on every subscriber up to $34.25 a month that we have not charged the subscriber because the federal government provides that to us in support. So that is the amount of money we lose. That is the key economic measure. That's the key harm right there in losing that $34.25. Now, you asked about the cost of service. I think it doesn't frankly matter for this reimbursement question. It matters perhaps for the takings question. But the cost of service is this. We have to provide and allocate a bucket of minutes, text, and data every single month to every subscriber, including those who are in the non-usage cure period. So we have to buy a provision and allocate that bucket of service to that subscriber. Just the same as we have to allocate it to another subscriber who uses all of it, and another subscriber who uses some of it. Our cost, think of it like a hamburger we put on the table, right? If I put a hamburger on each of your judges' tables, and Judge Rao, you eat none of it, and Judge Edwards, you eat half of it, and Judge Katsas, you eat all of it, my cost in serving that hamburger is the same thing. I can't take it back, and I can't reserve it to somebody else, not the same month or even the next month. I bought that service, and I use it, or I lose it. It's just like
you buy capacity user by user?
But we allocate chunks or buckets, as they're called, Judge, by user. And so we lose up to $34.25 in reimbursement every single month for every subscriber, and we are unable to recover our costs in serving those subscribers. But I would submit to you the more important element for this appeal is the fact that we lose that $34.25, up to $34.25, and we have been being paid it for serving these customers in their cure period for years until the non-reimbursement order was adopted. So I want to actually go quickly, if I can, through these rules. And I want to start with 407A. Because 407A says, by its plain language, universal service support shall be provided directly to eligible telecommunications carrier based on the number of actual qualifying low-income customers it serves directly after the first day of the month. 407A was amended in 2015 to include that concept of service as of the first day of the month. We call it the snapshot date. It is important because the FCC at that point in time filled a regulatory gap. Prior to that point in time, there was no date upon which a carrier had to count all of its customers for the purpose of submitting reimbursement claims. This rule clarified everything for the carrier and for the administrator. This is the date it is done. We take a snapshot of who you serve on the first of the month, and that is who we reimburse. So if the plain text of 407A says, support shall be provided to carriers based on the number of customers it serves as of the first day of the month. 407A contains no other limitation, and importantly, it contains no exemption to a carrier's right to receive reimbursement for a customer who is in the non-usage cure period, or any cure period for that matter.
Well, 407C2 carves out an exception.
Your Honor, I would submit to you respectfully that it does not in this case. It does not carve out an exception for subscribers for whom the 15-day non-cure period has not ended. And so if I can explain, 407C2 doesn't have that exemption. The plain text says the carrier shall only continue to receive universal service support reimbursement for such Lifeline service provided to subscribers who have used the service within the last 30 days or who have cured their non-usage provided for in 405E3.
Right.
By its terms, 407 says something about a carrier's right to continue to receive support. The word continue is important. It indicates that support is already being provided and that at some point in the future, it will only continue to be provided if something happens. Specifically, 407C2 says that a carrier should only continue to receive support for subscribers who have cured their non-usage as provided for in 405E3. That's important because the rule says is about what will happen going forward if and when a subscriber cures her non-usage as governed by 405E3. We take a look at 405E3, and a relevant text says, if a subscriber fails to use as usage is defined in 407C2 for 30 consecutive days, an eligible telecommunications carrier must provide the subscriber with 15 days notice using clear, easily understood language that the subscriber's failure to use the Lifeline service within the 15-day notice period will result in termination. So Rule 405E3, 405E3 by its plain terms says that if a subscriber fails to use within 30 days, the carrier has to provide 15 days notice to that subscriber, and he or she has 15 days in which to cure their non-usage. It's very important because the reference to 405E3 contained in 407C2 tells us that we cannot know. We cannot know under 407C2 which subscribers will have cured their non-usage as provided for in 405E3. We can't know it until 15 days have passed.
Doesn't C2 says who have cured, correct?
Yes.
Present perfect, which means the cure has already happened.
Yes.
And that's
So
the people we're talking about in this case have not cured.
yes, but they have not had their 15 days to cure. And the reference in 407C2 goes to 405E3, which provides subscribers with 15 days to cure.
If we were talking about a user in the cure period,
Yes,
and
we are.
I simply asked the question, and he hasn't yet cured. You ask the question, has that user cured? The simplest correct answer would be no, and the elaboration on that answer would be, yeah, it may be that that person has some number of days in which he might cure in the future, but he hasn't done it yet.
That's right, Your Honor. But the language of 407C2 is implementing a non-usage rule that gives consumers 30 days to use and 15 days to cure. It's a 45-day period. And the rule plainly says carriers will only continue to receive support after this 45-day period if the consumer uses or cures. It doesn't say what happens during the 15-day cure period. If it did say that, you would have to strike several words out of it. And I think that's what the FCC effectively does in its order. I think if it said what the FCC said it says, I think you would have to strike the words only continue to out of 407C2. And I think you would have to add the word not a couple times. You'd have to say, instead of saying to Lifeline service subscribers, to subscribers who have used the service, I think you would have to insert the word not, who have not used the service. And likewise, instead of or have cured their non-usage, I think you would have to say or have not cured their non-usage. But that's not the plain language of this rule. The rule contains those words, continue to receive, and is not phrased with nots.
I'm not following that because two conditions are imposed on, not on losing the right to receive reimbursement, but on continuing to receive reimbursement. You can continue to receive reimbursement if the person has used the service or has cured the non-use. Is that true? Right,
and we have asserted, and the FCC has agreed in their brief with us on page 23, that these customers who are in their 15-day cure period and not cured are in neither of these two buckets. Because they are in neither of these two buckets, this rule does not apply to them. This rule is carefully worded. It does not apply to them. And because it doesn't apply, 407A's language applies. There is a way to read all three of these together, Your Honor, and it is at the point in time in which the 15-day cure period ends. And at that point in time, if the consumer still has not cured their usage, then they are terminated under 405E3. And then the carrier's right to continue to receive support for them ends, it ceases under 407C2 and under 407A. That is the way you read these three rules together.
Mr. I'm interested in your argument that you're saying the people who are in the cure period but haven't cured are not encompassed within 407C2, right? Because 407C2 says, after service activation, an eligible telecommunication carrier shall only continue to receive service support for these two categories, right? People who have used it or who have cured it. So by saying that it's outside of that, I think you're admitting that you don't get the reimbursement, because you only get universal support reimbursement if you fall under one of these two categories. And you're saying that you're in a place that doesn't fall within one of those two categories. So I think that's to admit that you don't get reimbursement.
I'm not admitting that. And I think what you have to look at is the reference to 405E3. That reference is there for a reason. And it says, as provided for in 405E3, and 405E3 provides 15 days in which to do this. And so until that 15 days is up, I submit to you that 407C2, by its plain terms, does not apply, and that 407A does apply. When the 15 days is up and the subscriber doesn't cure, then they get terminated under 405E3, and they're not entitled to reimbursement under 407C2 and 407A. But that doesn't happen, Your Honor, until they are terminated and until their non-usage cure period is expired as provided for in 405E3.
How does the 15 days go to this question of whether they have cured their non-usage? They have 15 days in which they could do it, but whether they're on day 1 or day 15, if they have not cured it, then you can't get reimbursement.
I think, Your Honor, you cannot read out the 405E3 reference. You cannot read out from the rules here the 15 days that are provided for in 405E3. It says, as provided for in 405E3. It doesn't end with just non-usage. The statute, and what you're suggesting is perhaps to strike the words as provided for in 405E3, and I think the FCC would like that. But that's not the rule they wrote. The rule they wrote contains that reference, and that reference means that subscribers get 15 days to cure. And by the way, these rules require us to provide that service to these subscribers. During that period, we provide that discounted service to these subscribers to that period for 2 reasons. 1, so they can cure, and 2, because there's a benefit to them. There's a benefit for being able to pick up the phone and call emergency services or go online and find a job. There is a benefit to this that we provide to these subscribers even during the 15-day cure period. So I think if you look at the language that is provided to you in 407C2, and there's a lot of it, you have to look at the reference to 405E3, but you also have to resist the temptation to insert the knots that the FCC has asked you to insert into this rule that they did not write into it when they wrote it. They did not say shall not receive, they did not say have not used, they did not say have not cured. That's not what this rule says. That's not what the plain text of the rule says. You can read these 3 rules together. The FCC, by doing this work on 407C2, has no explanation for the reference to 405E3, and has no explanation for why 407A sits as it is with that mandate. There's no specific versus general conflict here, none whatsoever. The 3 rules can be read in perfect harmony. And so that's what I asked the court to do, because that is what had been done for years, up until the point the non-reimbursement order was adopted.
Thank you, Mr. Heitman. Judge Edwards, any questions?
No, thank you.
Thank you, Your Honors.
Ms. Flood. Ms. Flood.
Thank you. Good morning. May it please the court. Maureen Flood from the Federal Communications Commission. I agree with Mr. Heitman that this case is governed by the text of the Commission's rules, and the Commission's interpretation of the rules in the order is the only reasonable one. Subsection A of Rule 54.407 establishes how an ETC's baseline Lifeline reimbursement amount shall be determined, and then subsection C2 is a specific restriction on that general rule. It provides that after an ETC activates service, it shall only continue to receive support for subscribers who have used the service in the past 30 consecutive days or who have cured their non-usage problem. If the subscriber does not fall into one of those 2 categories, the ETC will not continue to be reimbursed. And that
What about 405E3?
405E3 establishes a process by which an ETC has to provide notice of the opportunity to cure the non-usage problem before de-enrollment, but it says nothing about reimbursement. reimbursement is handled by 54.407A. There is no temporal what Petitioner is trying to do here is read some sort of temporal restriction in subsection 54.407C2. It doesn't include one. If a subscriber did not fall into one of those two categories on the snapshot date, the ETC shall not continue to receive support for that subscriber. E3 only adopts or it only establishes this cure period, this notice period during which the subscriber can cure, but it has nothing to do with reimbursement. The reference to E3 in subsection C2 is only acknowledging that the cure period, the 15-day notice period during which the subscriber can cure, but it doesn't say that the ETC can claim reimbursement for the subscriber while they are in that 15-day cure period. And again, that has been the case since 2012. Petitioner, ETCs before the Agency Act even acknowledged that they could not claim support for subscribers in the cure period on the snapshot date. When the Commission adopted the snapshot date in the 2015 Lifeline order, it did so to mitigate ETC's reporting burdens by establishing a single date on which they would submit the line counts used to determine their general reimbursement support amount. But nothing in the 2015 Lifeline order mentioned subsection C2, the non-usage restriction, let alone amended that restriction so that ETCs can now claim support for subscribers in the cure period if that cure period fell on the snapshot date.
Ms. Flood, so what about the administrator of the USAC providing guidance in a different direction from what the FCC is arguing now?
Your Honor, the fact that the Lifeline administrator misinterpreted the Commission's rules does not mean that the Commission's rules are unreasonable. The plain text of the rules since 2012 has stated that an ETC cannot claim Lifeline reimbursement for a subscriber in the cure period for non-usage.
I mean, isn't the FCC is responsible for ensuring that the guidance given by the administrator is accurate, is it not, right? Because the administrator can't make any new substantive rules or issue guidance contrary to the rules, as you say, but that guidance was allowed to stand on its website.
Your Honor, what happened here, you're correct, the Commission is responsible for making sure that the Lifeline administrator follows our rules, but here the Lifeline administrator made a mistake. And that happened. That's what happened in the Solon's Academy case that the Commission relied on in the order on review and is discussed in the brief. Unfortunately, the Lifeline administrator will make mistakes from time to time. It put the incorrect guidance, which is one sentence, on its website in December 2016. That guidance was revised in December of 2017. So at least since December of 2017, ETC should not have been claiming support for subscribers in the cure period for non-usage. And I'm perplexed by Petitioner, the assertion made by Petitioner's counsel that ETC face years of retroactive liability here, given that they should have known since December of 2017 that they should not be claiming support for those subscribers. If they're going to rely on guidance from the Lifeline administrator that they like, they also have to rely on guidance from the Lifeline administrator that they might not agree with. You know, I'd also point out, and we raised this issue, or we cite the petition at page 39 of our brief, but in 2016, a group of ETCs filed a waiver petition with the Commission that asked the Commission to waive the non-usage rules so that they could collect Lifeline reimbursement for subscribers in the non-usage cure period on the snapshot date. In other words, their understanding of the Commission's rules was the same as the Commission's in the order on review. So given that they understood the rule to deny reimbursement, and given that the rule since 2012 has denied them reimbursement for subscribers in the non-usage cure period, when the Lifeline administrator posted that incorrect guidance on its website, ETCs should have followed the plain text of the rules, particularly given that they understood the rules.
But isn't the core point that they're making is there a group of subscribers for whom they will never be reimbursed even though they're required to give service? They've got to make an investment.
That is their argument, Your Honor, but
isn't that correct?
That is correct. There are some subscribers, if the subscriber is in the cure period and they don't cure their non-usage problem, then the ETC will not be able to claim reimbursement from them.
Even though they have provided service.
Your Honor, the non-usage rule in subsection C2 is not concerned with the provision of service by an ETC. It's concerned with usage. It talks about usage.
No, we're talking about getting the equivalent of reimbursement, or getting the support you would otherwise get.
That's correct, Your Honor, but again, this case is determined by the rules, and so here the text of rules of subsection C.
But that respectfully, counsel, that doesn't make sense. That's like saying if we have a rule that says we're just not going to reimburse you, then you lose because we have a rule that says we're not going to reimburse you. I'm trying to understand. They're saying that they are required to give service even during this non-usage period. They are required to give service by your rules. And they're saying, as I understand it, it makes no sense for them not to receive reimbursement for a period when they were required to give service.
Right. My response to that, Your Honor, is the Commission made the determination that they have to provide service in that period in 2012 when the Commission adopted subsection C2 and the 2012 Lifeline order. And there are good policy reasons for that. When the Commission adopted the non-usage rule, it did so because it didn't want to waste Lifeline.
They weren't getting reimbursement beginning in 2012?
That's correct, Your Honor. That is correct. In 2012, the Commission adopted the non-usage rule in 2012. And in 2012, the non-usage rule said that subsection C2 of the rule said that Lifeline, since 2012, the non-usage rule in subsection C2 has provided that Lifeline ETCs cannot claim reimbursement for subscribers in the cure period for non-usage. Nothing in that rule has changed. The crux of Petitioner's argument is that when the Commission inserted the snapshot date in subsection A in the 2015 Lifeline order, all of that changed. That ETCs subsequently could claim support for subscribers in the cure period for non-usage snapshot date. So in other words, their argument is key to the adoption of the snapshot date. But the non-usage rule, which focuses on usage by the customer, and that service has been in effect since 2012. And our point is that if the Commission adopting the snapshot date intended to redefine what is reimbursable under subsection C2, we probably would have mentioned subsection C2 in the 2015 Lifeline order and explained why we were effectively amending that rule, but we didn't. The snapshot date, which is the key to the Petitioner's argument here, was simply adopted by the Commission to mitigate reporting costs on ETCs when they file their reimbursement claims. It has nothing to do with what is reimbursable.
Ms. Flood, do you agree with Mr. Heitman's hamburger analogy, right? Is the FCC effectively saying that these ETCs have to provide a hamburger whether or not somebody eats it? And if someone doesn't eat it,
that's
then...
the same thing I'm asking, exactly. Yeah. That's certainly my understanding. I didn't hear you say anything to the contrary.
No, that has been the case since 2012. But I would point this out. In the order on review, the Commission considered the argument that the petitioner put in the record, that burden is significant and unfair. And the Commission found very little evidence in the record that the impact of that rule, again, a rule that has withheld support for ETCs, from ETCs for subscribers in this period of time since 2012, but the Commission found that that burden would be light. There was no evidence in the record about the amount of cost that ETCs would incur. There was no evidence in the record about the number of subscribers who are in the cure period for non-usage in the typical month. And so the Commission, and as the Court pointed out, an ETC is reimbursed if the subscriber eventually cures its non-usage problem. So there was no evidence in the record to contradict the Commission's determination that the burden of providing an unused service for at most a period of 15 days would be anything other than light. But I go back to the fact.
Ms. Flood, to the extent that the non-reimbursement order is, if we assume that the non-reimbursement order was consistent with the rules, as you suggest, then can the petitioners, they're not able to challenge the merits of the underlying rules at this point, are they?
No, really what petitioners, and we make this point in our brief when we talk about this issue about the impact on ETCs, but effectively in arguing that our interpretation of the rules places this undue burden on ETCs, that is an untimely collateral attack to the 2012 Lifeline order, because that's when the Commission adopted the non-usage restriction in subsection C2. And since 2012, ETCs have not been able to claim reimbursement for subscribers in the cure period for non-usage. And the interesting thing is, we did not hear these complaints from ETCs until the Commission adopted the snapshot date in 2015. But again, the snapshot date has no bearing at all in subsection C2.
Wait, let me make sure I'm following you, but I did think about this, following you on this argument on finality or reviewability, whatever you're suggesting. My understanding is they petitioned for a declaration, right? And the Commission issued an order in response to that and gave the interpretations that are now subject to our consideration, right?
Correct.
That's a final order that's reviewable, because there was confusion about what had gone up on the website. I would agree with you if there's nothing more than interpretive rules being thrown on the website, there's a question about reviewability. But they filed a declaration. You could have said, we're not responding. The agency did respond, and they responded with a final order and gave these interpretations, which we're now considering. That's reviewable. What am I missing?
Your Honor, our point is that the policy determination about where to make the cut in terms of the policy cut that ETCs cannot claim support for those subscribers was made in 2012.
I understand your argument about the rule. You switched in response to Judge Rao to suggest maybe this isn't even reviewable. And I'm not following that at all. You did not have to issue a reviewable order, but the agency did.
Your Honor,
right?
Okay. So
you're saying that your argument is that the order we issued is reasonable and certainly consistent with what we think we've always meant. But we agree there was confusion, so we took the petitions for declaration and we responded. And what we're doing, we think, is consistent with what we've always done. That's your argument, right?
Yes, that is very well put. That is my argument.
But that's a reviewable order.
That is a reviewable order.
You said that the snapshot date has nothing to do with this. This is all just about C2. But I'm not sure that's right. And as I understand this, if a subscriber didn't do anything if a subscriber didn't use the service for 30 days and the carrier cut the service off on day 31, that would be unlawful under this scheme, correct?
Yes, the carrier has to provide 15 days notice before cutoff.
So you're imposing on the carriers this affirmative obligation to continue providing service after a 30-day period of non-usage. And then you say in 407A, support is based on the actual customers served directly as of the first date of the month. And for a while, I was wondering if someone who hadn't used the service in 30 days might not be an actual qualifying customer, but under this scheme, on day 31 through 45, whatever it is, they still have this legal obligation to continue providing the service, and the snapshot date seems to treat them as actual qualifying customers as of that, if they're in that status on the first date of the month.
That's correct, Your Honor. The way the rule works is...
So if we just had 407A, the snapshot date strengthens the petitioner's case, correct?
Yes, if there is no subsection C here.
And that is at least some reason for trying to construe 407C2 and 405E3 in harmony with that. I mean, you're right, specific qualifies the general, but before we get to that, we try to harmonize all provisions so that there's no conflict to begin with.
Correct, Your Honor, but the problem with that reading in subsection A is that it renders subsection C2 superfluous. And we walk through the example in pages 23 and pages 24 of our brief. But effectively what petitioners are arguing is that subsection C2 is prospective only. In other words, it only eliminates support for subscribers once they've been de-enrolled from the Lifeline program. The problem with that is that subsection A already does that. Because if a subscriber is de-enrolled for non-usage, let's say in the middle of April, that subscriber pursuant to subsection A is not going to show up on the snapshot date under subsection A in the next month. So prospectively, the Lifeline ETC doesn't get reimbursement. Subsection C2 only performs work if pursuant to the second factor in subsection C2, it also eliminates support for the subscriber in the non-usage cure period on the snapshot date. In other words, subsection C2 only does any work if it eliminates support for 2 months instead of 1. And then I go back to the fact that subsection C2 doesn't have any sort of temporal restriction. I understand that petitioners don't like the construct that the Commission came up with, but our interpretation of the rules is truly the only way to reconcile A and C2 because it's the only interpretation that actually gives effect to subsection C2.
Okay. Judge Rao, anything else?
No.
Judge Edwards?
Nothing more. Thank you.
Thank you, Ms. Flood.
Yeah.
Does Mr. Heitman have any time?
Council is out of time.
We'll give you 2 minutes.
Thank you, Your Honor. Judge Katsas, in response to your question about qualifying customer, it's defined in Rule 409. A qualifying customer is an eligible customer. So the fact that a customer is in a non-usage period, it does not make them a non-qualifying customer. They are a qualifying customer. Now, with respect to going back to 2012, the rules 407A, the core of it, that says you shall be reimbursed, and the core of the non-usage rule 407C2 have been the same. They have been adjusted in 2015 to adjust the snapshot date into 407A, and the non-usage period has been condensed down from 30 to 15 days in 407C2. And so it is the case that based on the plain language of these rules, carriers have in fact been claiming reimbursement for subscribers served in the cure period for a long time. We said so in our brief. The FCC said it would only go back to 2016 in their brief, so in our reply brief we said fine, if we're only going to be exposed back to 2016, we'll agree to that. But the fact of the matter is there's exposure that goes behind that. And in 2016, you're right, it did crystallize for us, because as I explained, the 2015 snapshot idea crystallized the timing impact, right? It says 407A happens on a day, right? What you've not heard yet from counsel from the FCC is what 405E3 means, and what the reference to 405E3 means in 407C2. And it means that we have 15 days. So you have that 15-day period colliding with this 1 day. And the only way that you give all three of these rules meaning is that you pay the carriers a reimbursement for subscribers for whom the cure period has not ended, but they are still served as the first day of the month. You give all three rules meaning to the FCC's effect on day 16. On day 16, when the subscriber has not cured, they are terminated under 405E3. The carrier no longer has the right to continue to receive reimbursement under C2, and they don't get reimbursement under A. Thank you, Your Honors.
Thank you, counsel. Case is submitted. We call the next case.
Case number 19-7157, Service Employees International Union Local 32BJ versus Preeminent Protective Services, Inc., Appellant. Ms. Gaines for the appellant, Mr. Anderson for the appellee.
Good morning, Ms. Gaines.
Good morning, Your Honor.
Please proceed.
And may it please the Court, my name is Eden Brown Gaines, and I'm advocating on behalf of Preeminent Protective Services, Incorporated, one of the many small minority-owned businesses in the District of Columbia, which serves the city and employs a number of the city's citizens. I think this case illustrates some of the concerns that are inherent with very large and very powerful unions, and some of the flaws that can be inherent in the arbitration process. While unions certainly serve an important function in our society, I think that in this case, this union has become abusive. I think while the arbitration process can play a critical role in reducing the backlog of court cases and assisting parties in expediently resolving conflicts, I think this case illustrates part of the issues with the arbitrator's desire to ensure income and making that focus the primary focus of the process rather than the merits of the actual issue.
Before we get to the merits here, there have been some substantial questions raised about jurisdiction. So can you walk us through why you think that the order compelling arbitration and the contempt order are before us? Because you didn't appeal those orders within the 30-day time period.
Sure. Under the district court assumed jurisdiction pursuant to the Federal Arbitration Act. And under the Act, Section 9 USC Section 16B, an appeal may not be taken from an interlocutory order under the Act directing arbitration to proceed. And so Preeminent was not in a position to appeal the court's order directing that it go to arbitration at the time that the court entered the order.
Except that Greentree says that an order like that is not interlocutory under B4, it's final under A3.
Well, I don't think that the order directing them to arbitration, just under the plain language of the Federal Arbitration Act statute, would have been directly appealable at that time. I mean, typically, when the order ensues, the parties must be directed to go to arbitration, and then at the close of the case, when the case is finally dissolved or disposed of by the court, then at that time the parties are in a position to be able to appeal whether or not the order.
How is this order compelling arbitration different from the one that was held to be final and appealable in the Greentree case?
Because in this case, the court retained jurisdiction and continued to exercise its authority throughout this proceeding. If the court recognizes the fact that when...
How do you get that? If you look at the arbitration order, he just grants summary judgment and compels arbitration, and the order on its face just grants summary judgments. It seems like the district court was dissociating himself from the case.
I mean, I think we can look at what occurred after the judge's order to direct the parties to arbitration. I mean, the case was not closed by the court. The appellees were able to file a motion for contempt of that order, and the proceedings continued as if it was the same case, not the reopening of a new case, not in the posture of a case that had been closed and an order being revisited. And so, I mean, I think this case falls within the context of an interlocutory order under the Federal Arbitration Act statute, meaning that Preeminent would not have been in a position. If we had filed an appeal at that time, then the court would not have had jurisdiction, and we would have been sent back to go through the proceedings until the case was finally concluded. Would you also like me to address the issue with respect to the civil contempt order?
Yes, please.
with respect to that, the course of held on civil contempt order is not typically deemed interlocutory and thus not appealable. This district has generally taken that position, and then there's a well-entrenched Supreme Court case law that essentially stays the same, and it describes the rule as well settled. And so again,
your case for the contempt order being interlocutory seems very intuitive to me. There are attorney's fees issues that are still pending, and the contempt order looks conditional on its face. But we have Budinich, which seems to tell us that the pendency of fee issues doesn't defeat finality. And we have a case from our court called Armstrong, which says that if an order is conditional in the sense of it says, here's what you have to pay unless you cure a contempt, we said that was a final contempt order. So how do you get around Budinich and Armstrong?
Well, I think this case is a little different because the court did not say, here's what you have to pay when initially issuing the order of civil contempt. The appeal came within 30 days of the time in which the court finally said, here's what you have to pay. And it would just it would be nonsensical in the sense that Preeminent's arguments concerning the propriety of the sanction, meaning whether or not it was punitive in nature, meaning that it should be treated like civil contempt, whether or not they had the ability to pay it, all of those arguments aren't ripe actually until the parties know what the actual sanction is going to be. And so it was conditional contempt, meaning that if Preeminent didn't take some act in the future, then the court would take certain acts, and those acts didn't happen when the court initially entered the civil contempt order. And then, of course, we didn't know what the court was going to order Preeminent to pay finally until November, and then Preeminent appealed that order within 30 days.
Ms. Gaines, if I could ask you a question about the order. So there's a conditional contempt order. It seems that the district court's order of that date does two separate things. It imposes a conditional contempt on Preeminent, right, which actually gets purged, right, because Preeminent does arbitrate within 1 month of that order, right? So Preeminent is actually never held in contempt. But I think that order does also a separate thing, which is impose attorney's fees irrespective of the contempt, right? I mean, the attorney's fees at that point are not connected to the contempt. It's sort of, the contempt is purged, but the attorney's fees continue, right? So it seems if you think of the order as doing those two distinct things, then the order saying that there will be attorney's fees, is final and appealable as of the June order, because it's a determination, a final determination that there will be attorney's fees awarded, and the only thing left is to figure out the amount.
Well, let me answer that in two ways with the court's indulgence. The first issue was that there was some difficulty in determining exactly what it is the court was doing. If the court recalls from the record, the court actually, I believe in the first hearing, the court said, I'm not going to hold you in contempt at this point. And then, more things happen. We get to the court in January, and then the court says, I'm going to order attorney's fees, but isn't clear under what authority the court is making that order in January, because the court doesn't actually make a contempt finding. And so there's this question as to whether the award of fees at that time was pursuant to the court's inherent authority, some statutory mechanism. And so we've raised that issue in the brief. And I think it was the responsibility of the court to be clear under which method, whether it be contempt or pursuant to contempt proceedings or the court's inherent authority, as to how, these attorney's fees awards were going to be issued. But then to answer the second part of your question, again, I think it's what I'm saying earlier about how this award is manifested. Preeminent would not have been able to appeal the issues with the contempt award, meaning whether this award was punitive or compensatory in nature. None of those things were readily apparent until the final amount of the award was in place. And so Preeminent's concerns obviously were with the fact of the award, and the court wasn't very clear on how it was issuing this award because, as you correctly noted, Preeminent was found in civil contempt by the order, but obviously they were able to, it was conditional and they were able to meet the conditions, that the court had imposed by going to arbitration. But the rest of the aspect of the order was still kind of in the air until the court actually heard the parties' positions and then entered.
Is it in the air, though, under Budinich and Armstrong, as Judge Katsas had mentioned, though? Because those cases do seem to suggest that when there's an order saying that there shall be the payment of attorney's fees, that is a final and appealable order.
But I think as Judge Katsas pointed out, it said what the party would pay. And in this case, it was broken out. There wasn't quite the determination as to what the party would actually pay.
You're right about that, but the order that we held to be final in Armstrong, it was a coercive civil contempt like this one, and it said to the executive office of the president that you will be sanctioned X dollars per day unless you purge the contempt by coming into compliance by some future date certain. And it sounds awfully contingent to me, but we said it was final.
Well, there are two parts to our order, though, that's a little different than what you described. Yes, the court here did say you'll pay X dollars per day unless you do something in the future, but then the court also said you're going to pay X dollars for some unknown amount to be determined because of...
On the fees.
That's right, your contempt or, it's hard to tell from the court's orders whether the attorney's fees is a penalty under contempt or it's, the court's inherent authority to supervise, its orders, like whether the judge issued this attorney's fees amount by its inherent authority or whether it was pursuant to the contempt. But in either case, this is a little different.
Ms. Gaines, the order does say that the fees are the order says, to compensate the plaintiff for the defendant's contemptuous and dilatory tactics, and regardless of any subsequent purgation of the defendant's contempt, which seems to me to decouple the contempt from the attorney's fees, right? So even if you were to purge the contempt, the court is making clear that there will be attorney's fees awarded.
It's still tied, Your Honor, back to what happened in January, because if the court recalls, the district court actually said in January that you're going to have to pay attorney's fees, required the parties to put in petitions, and didn't say exactly what those fees would be. And so then when we move forward to the point where the court is issuing the conditional contempt order, it's also bootstrapping in the conduct, the attorney's fees, everything that had occurred, at least from January, going forward to the future. And so it just isn't at the point of making the statement that you're in civil contempt. The court initially just said, hey, I'm going to make you pay these attorney's fees because I don't like what you did, or, you're kind of in contempt. And then the court moved forward after the arbitration broke. I'm sorry. Did I interrupt someone?
No, it's...
Okay.
Go ahead.
I'm sorry.
Oh, that's okay. After the arbitration broke down with Arbitrator Johnson, then the court moved forward to say that this is a conditional attempt order and states the issue as you said. And again,
go ahead.
The attorney's fees, it's no problem, Your Honor, I got it. The attorney's fees is tied to the court's concern, I suppose, for lack of a better word, with its belief that Preeminent had failed to follow its orders, whether by the letter and spirit, and moving forward, to proceed to arbitration. So, I mean, I think the court has jurisdiction because I think both orders were of the nature that had Preeminent appealed the first order when it occurred, this court would have said, we don't have jurisdiction, we're going to send you back because of the Federal Arbitration Act. And I think had we appealed the contempt order before the attorney's fees had been known, not only would Preeminent, have been in a position where they couldn't have made the arguments because they wouldn't have existed yet. They wouldn't have known what the fee was going to be and what the problems were going to be. In fact, again, Preeminent's argument is that this isn't even civil contempt.
Let me ask you about your understanding of the FAA. The order to arbitrate is final unless stayed under the FAA.
Yes, sir. So
it wasn't stayed here.
That's correct. That's correct.
So it's final.
It's interlocutory in the...
No, it's under the FAA. It's final unless stayed.
I don't know that I read the language of the FAA in that way. I mean, it simply just says an appeal may not be taken from an interlocutory order directing arbitration to proceed. And I'm not sure that the statute speaks to whether or not the parties requested or the judge decided to stay the order. I mean, I think Preeminent did have to continue to arbitration based on the court's directive and then await the final conclusion, whether the arbitration award was confirmed or whether it was vacated or altered in some way pursuant to the statute before it can ultimately appeal the court's decision. And I think that is actually what Preeminent ultimately did, and in so doing, that this court is able to take jurisdiction over the matter.
Can I just ask you one question on the merits, if we were to reach them, about the arbitrability question? The collective bargaining agreement that includes the arbitration clause is between Preeminent and the union, right?
Right.
Yes.
Right, not between the individual employees, right? A collective bargaining agreement is by definition between Preeminent and the union.
Yes. Yes. So I think the problem with the collective bargaining agreement in this instance was whether this was the applicable collective bargaining agreement. So I think the issue that ultimately had to be determined was not whether you could grieve or go to arbitration on a termination grievance. I think the issue was whose collective bargaining agreement was applicable, because Preeminent's argument is that it was not the employer of the grievance. Preeminent couldn't even say, other than reading emails that it received from the District of Columbia, why the grievance had even been terminated. And ultimately, when the arbitration went forth, the grievance testified that they'd never, been terminated by Preeminent, that it hadn't been communicated by them. So that fundamental issue was just that whether it was the district court to determine it, and it's Preeminent's position that that was the responsibility of the district court rather than the arbitrator, because this was not an issue of whether, the parties were arbitrating a proper grievance or whether it was an interpretation of the collective bargaining agreement, but instead it was the very issue of whether the contract even applied, whether this was the appropriate mechanism to be able to force the parties into arbitration. Even the arbitrator, the initial arbitrator, believed that as well. And that's why he stopped the arbitration and dismissed it, because he believed there was a jurisdictional question that actually should have been resolved by the district court. And in this case, the district court thought the other way. The parties proceeded to arbitration because they were following the district court's orders. And ultimately, we're here because that overall issue from the beginning needs to be looked at too. But I think more importantly, even if the court didn't feel that it could take jurisdiction or discuss whether or not the district court should have made the ultimate determination, I think in looking at the contempt order, I think this case still has to be reversed, because the law is very clear that a contempt order has to be very specific. It's got to tell a party what they should and shouldn't do. And there just isn't any, evidence in this record that suggests that Preeminent, whether actually or even in spirit, was in contempt of the district court's order. Preeminent went to arbitration each time. I don't think that saying that a second separate agreement wasn't necessary is contumacious conduct. I think the court did in fact order Preeminent to pay the fees, but we just kind of never got to that issue. It took a long time to even get to the decision as to whether Preeminent was the appropriate employer. So there's just never any evidence of a bill that wasn't paid, or, you know, an arbitration fee that was due or owed by Preeminent that didn't occur. We didn't get to it until ultimately the parties went to the final arbitration, and then the arbitrator made ultimately a determination in Preeminent's favor. And at that time, he sent an invoice, as is the usual process. And based on the court's orders, Preeminent paid that invoice. And just to speak really quickly to the issue of just the attorney's fees in general, and I think this is very important for the court as well, and it highlights the nature of the punitive nature of the sanction rather than the compensatory nature. A civil contempt order is supposed to be compensatory in nature. It's supposed to compensate or repay or make whole a party for what they lost. And in this case, we never even received a bill in the record demonstrating what the union actually paid for the conduct that the court considered contumacious or against its orders. And the only evidence submitted in the record was the evidence of the market rate by another union official who said what the typical rate in the Washington metropolitan area should be. So the fees that the court awarded far exceeded what is typical in the market rate, which the law says the court must consider. And
there's a very long line of cases involving fee-shifting statutes which allow use of market rates. 32 USC 1988, for instance. There's no suggestion in any of those cases that a market-based fee award is a criminal sanction.
Well, our argument, I'm sorry.
Those awards are routinely applied through civil processes.
So the point here, Your Honor, is that it wasn't a market-based sanction. There was an affidavit that Preeminent submitted again by a union official that stated what the market rate or the range for the market rate was in the Washington metropolitan area. That was the only evidence that was actually presented in the record of the market rate, and it was about $200 less than what the union was relying on for fees. They used the Laffey matrix, and I think it was the U.S. Attorney's Laffey matrix,
which is some attempt to approximate market rate.
Well, we cited
and your theory, as I understand it, is the outer bound of the sanction has to be not the market rate, but what the union actually paid in legal services.
Yes, sir.
The reason you say that is if you go up to market rates, that makes the sanction, that makes the fee award criminal in nature.
Not quite. Yes, absolutely, on the point that it wasn't what the union actually paid, but not with respect to going up to market rate, because in this case, we didn't just go up to market rate, we exceeded the market rate. We went well and above the market rate. So yes, the premise is that it has to be compensatory in nature, and it really just should have been what the union paid, absolutely. But even if the court were to contemplate that the market rate was a fair rate and it was reasonable, this wasn't a market rate case. This was a case where the Laffey matrix was applied, and we cited case law in the brief that this court has determined that the Laffey matrix isn't applicable to every circumstance.
Isn't the assumption here that the union counsel is the equivalent of a public interest attorney who can claim market rate? Isn't that what was going on?
No, that's not what happened. Even if the court were to determine that based on the union service as kind of a public interest attorney that they could claim market rate, they didn't claim the market rate. The market rate was $250 or $200 to $350 an hour. They received a rate that was about $220 in excess of that. And the Laffey matrix is not the market rate. So that's the other part of Preeminent's argument, that the court applied the Laffey matrix. There's case law in the circuit that says that that isn't the market rate for these kinds of cases. And then again,
say these kinds of cases, what do you mean?
A union case. the Laffey matrix in this circuit is applicable to employment discrimination cases, and then the court has a body of case law that just speaks to the rate being something that is commensurate with the work in the industry, the level of experience, et cetera.
Well, what is there some specific case you have in mind that says a union rate can't be the Laffey rate or can't be the market rate? I'm not.
It doesn't. The case doesn't. I'm sorry, Your Honor. I could go to it if I could look at my brief, but I'm afraid I'm going to make the doom drop off. But we cited to the case in the brief, and the case actually says that the Laffey matrix is for employment discrimination. It's not cast in the way that you just stated it, that it cannot be used for union cases, but it says specifically it's for the employment discrimination, and it has another statement that gives kind of like a generalization for cases. But I believe here the market rate is determined by the other body of case law that we cited in the brief from the DC Circuit that speaks to the prevailing market rate for the industry, the attorney's level of experience, et cetera. And again, the only information that's even in the record is what Preeminent presented from another disinterested union official that basically said what the market rate is for attorney fees, gave a range in this area. So the fact that the fees awarded in this case exceeded even the market rate makes it even more clear that this sanction was more punitive in nature rather than compensatory, and that, of course, Preeminent wasn't afforded the protections that are inherent when issuing a punitive or criminal-like contempt sanction.
I thought the Laffey index was a device for estimating market rates.
I wish I could do that in every case because it would be quite a bit at this point. But no, it isn't. The case that we cited in the brief makes plain that the Laffey matrix isn't necessarily the benchmark for determining the market rate. And I think inherent in that, when they speak to employment discrimination cases, I think that the courts are probably considering just how you get to a certain point. Employment discrimination cases are typically contingency-based cases, the risk that is inherent in the case. If you look at the regular Laffey matrix in DC, an attorney for 20 years is about $890, and the U.S. Attorney's matrix, it's closer to $700. So that's based on risk, et cetera. In this case, we know what the market rate is for union attorneys because there's an affidavit in the record that says what the market rate is for union attorneys, and it was essentially undisputed. And so when
you say union attorneys, do you mean just the in-house counsel, or do you mean the outside lawyers as well, the law firm as well? The outside lawyers. The evidence that we submitted spoke to outside lawyers. I mean, I think there is case law that supports the concept that in-house counsel, that their hours, if they keep them, accurately and in the manner and way that the courts typically acknowledge, that they can recover for some of the work they do despite the fact that they're salaried and they're paid in-house. But this is the prevailing rate for outside counsel. And just as the court has acknowledged, their union attorneys are often considered a public interest attorney. The rates are typically reduced. But again, because of the nature and the clear case law in civil contempt that it must be compensatory, meaning it's just got to basically be what you paid, what you lost. There really isn't supposed to be a windfall, or that can convert it to a criminal. That's an argument about civil contempt being different from fee-shifting statutes. I'm having trouble understanding your argument about why union counsel, as opposed to company counsel or somebody else, should be treated differently.
Well, I wouldn't focus on who it is. I would focus on the industry, the work that's being done. I mean, you can have the same attorney take on a case on behalf of a union and perhaps do a merger or acquisition, and the rates could be different because of the nature of the case. But the market for work within the industry, grievances, determinations of collective bargaining agreements, arbitrations, that kind of work has a certain market rate. that unions, when they seek counsel, typically outside counsel, pay in the Washington metropolitan area, and it isn't the Laffey matrix. There's evidence that unions aren't paying what the rates are in the Laffey matrix. I suppose if the union had put on evidence that this is what the Washington metropolitan area requires for unions, then we'd be having a different conversation, but they didn't do that. The only evidence in the record is actually just the affidavit that says that this is what unions typically pay for this kind of work in the arbitration context, and that is what the court is supposed to look to. And then I can't see my time, but just to briefly mention, another just concern for my client is the court kind of ignoring the evidence about Preeminent's ability to pay, because this could turn into a situation where you have business officials being jailed or held in contempt when they absolutely don't have the means or the ability to purge themselves of it. And obviously contempt should be something that someone can pay in order to deter, and effectively administer.
Isn't it your burden? If you want the sanction reduced based on inability to pay, I would think it's your burden to show that.
Yes, sir, I believe that's true. And
District Court didn't ignore the evidence, looked at the evidence and found that you hadn't discharged your burden.
I mean, I think the court's review of the evidence was erroneous. I mean, Preeminent put in their financial statements that showed a clear loss. As Preeminent demonstrated that they were no longer a contractor on the DC citywide contract, and that was 90% of their revenue as a company. They also showed that they had been the victim of fraud and that they had lost $750,000, and that this was an issue that was actually being prosecuted by the U.S. Attorney's Office in the Eastern District of Virginia. They showed that they had a negative income position. So, I mean,
So your position is that his finding on that point is clearly erroneous?
Yes, sir, based on the evidence that was presented in the record.
Judge Rao, any other questions?
No.
Judge Edwards?
No.
Thank you, Ms. Gaines.
Thank you.
Mr. Anderson.
Good morning, and may it please the court. I'm Michael Anderson, Service Employees, Local 32 BJ. I'd like to begin with the appellate finality questions here. The May 9th, 2018 order compelling arbitration was a final order under the FAA 9 U.S.C. Section 16A3. And Judge Katsas is correct that the Greentree case qualifies an order like that as a final and appealable order. This was not a case where the union brought multiple causes of action, where the arbitration only went to one of the claims, where there were other non-arbitrable claims that were awaiting final judgment. In this case, the order compelling arbitration was the sole relief the union sought in its petition, so that the district court's order granting summary judgment on the only merits claim and granting the only relief the union sought was final and appealable.
What would fall under 16B4, which says that an order directing arbitration to proceed under A4, which is the provision, under Section 4 of the FAA, which is the provision we're talking about here, is interlocutory?
True, because that's in the context of there being other claims in the mix which had not reached final judgment. But as the Supreme Court held in Greentree, if the only relief the plaintiff is asking for is an order compelling arbitration, then that's a final appealable order, and the losing party doesn't get to claim that the finality is somehow postponed until the arbitration is complete.
And then what do we do with the fact that while the order compelling arbitration seems final in the way you describe, the district court didn't close the docket on 17-16-79, and when all of these enforcement and contempt issues came up, they picked up in the same case rather than in a different enforcement case.
Because all district courts continue to have jurisdiction to enforce final orders through contempt proceedings. So, for example, if Preeminent had brought a timely appeal immediately after the May 2018 order, the union would not have prevailed on a motion to dismiss the appeal just based on the argument that there might be some future non-compliance with the order that might trigger further orders to show cause and contempt applications. A district court's inherent power to enforce its own final orders through contempt proceedings does not detract from the finality of the underlying order. If it did, then parties in contempt proceedings would always be able to circle back and tell the appellate court, well, we shouldn't have been enjoined in the first place. And that's what's clear that parties in contempt proceedings are not allowed to do.
Okay, what about the contempt order?
The contempt order, the distinction that matters for purposes of the court's decision here is between pre-judgment civil contempt orders, which are interlocutory and are governed by the final judgment rule, versus post-judgment orders. That's the distinction that shows up in the cases that the parties have cited in competing briefs. In the cases cited in the Preeminent reply brief, Bird versus Reno and Machinist versus Eastern Airlines, the contempt orders had issued prior to a final judgment on the merits of the litigation. In Bird, it was a discovery order compelling production of audio tapes in a Title VII action. In Machinists, it was contempt of a preliminary injunction, even as the parties continued to amend the complaint and proceed to a final judgment on the underlying merits. In this case, however, if I've persuaded the court that the May 9th, 2018 order was a final appealable order on the merits, the subsequent contempt citations are post-judgment civil contempt orders. And that brings them within the scope of Armstrong and Gwynn, the two DC Circuit cases I cited in the briefs. And there's a long string of appellate authority that draws this distinction. It explains that post-judgment contempt orders are immediately appealable because they don't raise the kind of problems under Section 1291 about final judgments that would occur if they occurred before, prior to the final judgment on the merits. So for that reason, Preeminent, if they were aggrieved by Judge McFadden's findings in the June 9th, 2019 civil contempt order, they had 30 days to bring that to the court. Because they didn't, they are no longer in a position to say, we shouldn't have to pay these fees because we weren't in contempt to begin with. That is what this court said in Gwynn. That is also, that is also what other courts, for instance, the Sixth Circuit in Genesis versus Green, have said.
I didn't hear what you asked, Judge Katsas.
Sorry, go ahead.
No, did you ask something I didn't hear?
Yeah, it just seems very odd to me that for a civil sanction like this post-judgment, but a coercive sanction which says it'll be $20,000 unless you cure the contempt by such and such date, and then $20,000 every 2 weeks thereafter. Baked into that is a need for future proceedings to figure out whether the contempt was purged and how much the sanction should be. So you're positing one appeal of the order imposing the sanction on the front end, and then a separate appeal on the back end when the district court says, well, the contempt wasn't purged in time, and it was purged in the second week after, so the sanction is $40,000 as opposed to 20 or 60, and that's a separate appeal. It just seems very strange.
I understand, Your Honor, but that's really an argument against this court's decision in Armstrong.
Right.
And in the attorney's fees context, that's also an argument against the Supreme Court's rule in Budinich, that when the Supreme Court says that the fixing of the amount of the attorney's fees does not affect the finality of the underlying order, the Supreme Court really is making a choice that sets up the need for two separate appeals. The first appeal from the order that awards the attorney's fees, and the second order that fixes the amount. But that's inherent. Yes.
I can't figure out a way around Armstrong, but let me take a crack at Budinich, which is to say that case holds that the fee issues are collateral to the merits issues.
Mm-hmm.
Here, the merits issues are the order compelling arbitration, and we're having this conversation on the assumption that you've won that issue. That was final. Now we're talking about everything that flows from non-compliance.
Correct.
And the question here is whether one set of consequences, which are attorney's fees, are collateral not to the merits, but to the contempt. And you can think of the contempt and the fees as just everything bad that might happen to a party because it disobeyed a judicial order. That's a little bit different from Budinich, which is fees are collateral to merits.
Except that Budinich was trying to resolve a circuit split where many courts follow the line of reasoning that you're proposing now and made delicate distinctions between fee orders which were like damages versus fee orders which were like costs. And they applied different rules of finality to each one. Budinich takes a very broad brush approach and says no matter what the statutory or equitable or contractual basis of the fees, litigation over the amount of fees does not toll the finality of the underlying order. And that applies just as much to contempt as any other case. When I mentioned the Sixth Circuit's decision in Genesis versus Green, which is cited throughout in my brief, although that was a Sixth Circuit case, it was actually written by our late district judge Oberdorfer, who was sitting by designation in the Sixth Circuit. He didn't make the opinion any more binding on this court, but his analysis of how attorney's fees in contempt sanctions work in relation to Budinich is persuasive and correct. And I would urge the court to follow Judge Oberdorfer's analysis in Genesis. So what that means is that if Preeminent believed that it had not in fact been in contempt of Judge McFadden's May 9th, 2018 order, it had 30 days to bring an appeal where it could raise all of its arguments about how everything that it did in the 13 months between the arbitration order and the contempt order was not in fact contumacious. But if that 30-day period elapses without an appeal, then the court simply doesn't have jurisdiction to use fee litigation to circle back and say, well, we don't think Preeminent should have to pay any fees because they weren't in contempt to begin with. That is what Preeminent is urging you to do, and that's contrary to the finality rules that are set forth in cases like Genesis, as well as U.S. versus Gawain. If I may turn to the merits of the amount of the fees, unless the court has further questions.
Go ahead.
Okay. It's a bit frustrating to hear Preeminent argue even now that there is a DC Circuit decision that says that the Laffey matrix is not applicable where the litigation occurs in some, sub-corporate market like union rates. Because the only citation that's given for that proposition in the briefs is on page 26 of the appellant's opening brief. And it reads Covington versus District of Columbia, 57 F3rd 1101 and 1113. But when you look that site up, you find that that is a citation to Judge Henderson's dissent in that case. And that was, in fact, the very proposition that the majority in Covington, written by Judge Edwards, rejected, saying that the Laffey rates state the prevailing market rate, and there are no second-class markets within the legal community. And that's particularly true when it comes to union lawyers. As the record reflects, my partner Arliss Stevens and I have good credentials as anybody that works for large firms that serve wealthy clients. I'm a 1987 honors graduate of Harvard Law School. It is true that I and Arla Stevens bill our clients, our union clients, at less than the full LAFI rates. But the entire premise of the lodestar jurisprudence, both in this court and in the Supreme Court, is that the prevailing hourly rates within the market, and in the District of Columbia, that's defined by LAFI, apply whether I'm a pro bono counsel for a legal aid clinic or simply an ideologically motivated public interest lawyer who works for workers organizations.
Can I ask a different argument, which is, why should we extend those are all cases involving fee shifting statutes.
Mm-hmm.
Congress gives the courts authority to figure out what is a reasonable rate, and the existence of the fee shifting statute is thought to reflect Congress's inducement to have talented lawyers like yourself bring cases that otherwise wouldn't be brought because they want private enforcement in some area.
Mm-hmm.
All of that is fine, but this is civil contempt. There is no fee shifting statute, so the background rule would be the American rule, that each side bears its own fees. The only exception to that is inherent power, which is to be cautiously exercised. And we have the Supreme Court in Goodyear telling us that if the sanction is an award of fees, it has to be precisely to compensate the client for the amount it was forced to pay because of the contemptuous conduct. And here, whatever your motives for lowering your rates to your client, the injury to your client is what they had to pay you because of the contemptuous conduct on the other side.
Understood, but even one of the earliest Supreme Court decisions on the lodestar, Pennsylvania versus Delaware Valley, was a contempt case where they approved the lodestar in a contempt context. What's more, the argument that you're sketching here is effectively no different than the argument that the losing defendants made in Save Our Cumberland Mountains and in Covington. The argument is that, well, even under ordinary fee-shifting statutes, all the client is entitled to is an award of their attorney's fees. And if they didn't actually have to pay any attorney's fees because they had a pro bono counsel or had discounted fees because they had a public-spirited counsel like myself, then it would become punitive damages. It would exceed the compensatory intent of the fee-shifting statute to allow the plaintiff to recover something in excess of the actual rates.
Well, but the question my colleague is asking, in Cumberland, was there a fee-shifting statute? There is no fee-shifting statute here.
No, that follows from the power to award civil contempt, correct?
Right. But I mean, that's the whole point. I mean, the premise of this question is, in those circumstances where there are fee-shifting statutes, we do what, wasn't Cumberland a fee-shifting statute?
Yes.
I believe it was Section 1988.
Yeah, so I mean, so you're not really answering this question. This question is, is there any case law that says, you said there's an old Supreme Court case, which I'm not aware of, I'm not saying it's not there, but that hasn't been normally. Our normal routine is to apply fee-shifting statutes and to follow the LAFI matrix. That's true. But has that been done in situations like this?
In my brief, I cited a long line of federal cases that apply the lodestar rates in contempt and in Rule 37 sanctions cases where the same considerations would apply.
Okay.
I looked and found district court cases, but no Court of Appeals cases. I'll take a look at Delaware Valley. I missed Delaware Valley. I'll take a look at that. But do you know of any Court of Appeals cases? All the cases that the parties.
Yeah, there's the Teledyne Technologies case on page 34 of my brief.
Okay.
Tell the court that's a federal appendix case. It was not published.
Okay.
But that's where the Seventh Circuit, at least in a federal appendix case, applied the lodestar.
Is Barrow consistent with what Barrow v. Falk? I just don't remember.
I'm sorry, I don't have that in front of me, Your Honor.
All right. I'll have to look at that again.
Okay. Anything else you want to tell us about ability to pay or things we haven't covered?
Oh, well, on inability to pay, the district court had a full evidentiary record from which it discredited Preeminent's claim of inability to pay. Preeminent has not even provided you with any of the exhibits on either side in the excerpts of record. If you need to go back into the ECF dockets to see, you'll see that the district court had ample reason to judge from what Preeminent said on its own website that it has revenues of $25 million a year, that it always meets all of its financial obligations, so that a $51,000 fee award does not seem to be outside the ability to pay. And finally, I think that to the extent the court is interested in the question, take a look at Judge Easterbrook's analysis for the Seventh Circuit, where he says that it is a circumvention of the bankruptcy code for courts to give ad hoc debt relief because one party claims insolvency, where all other creditors are not also brought into the process. If Preeminent genuinely can't pay, it has a remedy under the bankruptcy code, and then the bankruptcy court can allocate who's entitled to what percentage of its obligations. But to ask for a one-sided debt relief against only one creditor in a non-bankruptcy proceeding effectively frustrates what Congress expects in the bankruptcy code, and that's persuasive. And I have nothing further unless the court has more.
Judge Rao? Judge Edwards?
No, I'm fine.
Okay,
Thank
thank
you.
you, Mr. Anderson. Ms. Gaines, we'll give you 2 minutes.
Yes, sir. I mean, I think it's just important maybe to go backwards so that the court can see that there is something to do here. I mean, if we just go from the award of attorney's fees and the arguments concerning the attorney's fees, the court certainly has jurisdiction to determine whether the fee was proper, whether it came in the right context, because that didn't come until November, and this case was appealed within 30 days of that particular award. And then moving backwards to the conditional civil contempt award, the court has to consider the fact that because it was conditional, the court still had to do something after entering that order. It had to say you didn't do what you were supposed to do, and here's what we're going to do, or you did do what you were supposed to do, and here's what we're going to do. And the court really didn't do that until November. And so this court has jurisdiction certainly over those issues. And then moving back to just the issue about compelling arbitration, 16b says that an interlocutory order is not appealable if it's this type of order, and then the court is wondering how this is interlocutory. I think we just have to look to what happened. Again, the court, it says that the case has to be disposed of, the case has to be dismissed, and the court did not do that. The court continued to exercise its jurisdiction in the very same case, as the parties proceeded. With respect to the arguments about ability to pay, I think there was just a conflation of when something is reduced to a judgment versus when it comes in the court's exercise of its inherent authority to have compliance with its orders or contempt. Had it been reduced to a judgment, then perhaps, of course, Preeminent could dispose of it through a traditional debt-related proceeding. But this is a contempt award. So if Preeminent can't pay the order, then again, it's officials can be jailed and until they actually it becomes like a debtor's prison in that way until they satisfy the court. So whether or not you can purge yourself of the contempt is an important consideration and factor. And I think financial statements are more important than what's stated on an outdated website. And Preeminent certainly put in its actual financial statements. They're in the record because they were under seal because, of course, of the trade secret aspect of those statements that showed that Preeminent actually did not have the money in order to do it. And then another thing, if there really was an issue based on what was that issue, the court should have held a hearing. The court did not allow Preeminent the opportunity to have an evidentiary hearing where, they sent in an affidavit, they sent in their financial statements, but where there could be this, competition of whether the internet site was important versus their actual financial statements. So, I think this is a different context. It's not a debt. It's not something that can be discharged in bankruptcy. It's the court requiring, and in fact, the appellees actually filed a subsequent order asking for, again, contempt for Preeminent not paying before the bond was put up in this case, because before the PPP, Preeminent didn't even have the money to put up the bond. And so I think we're just in a different context.
Thank you, Ms. Gaines. Do my colleagues have anything else? Okay, thank you. Cases.
Thanks, Your Honor. Nice meeting you all.
Thank you.
Thank you.
Thank you.
This honorable court is now adjourned until Thursday, October 15th at 9:30 a.m.
Goodbye.